Okay, so good morning, good afternoon. How is everyone doing? Hanging in there?
Hanging in there.
Okay, good, good. All right, um, so I want to get started by just checking in, right, as we do, um, making sure that you understand what we covered last week. So there's two parts to this. The first one is you explaining to me what you think you got out of last week's lectures, and that's intended to let me check in and make sure that what I think I'm teaching is what you're learning. And then the other piece of it is for you to ask about anything that you are unclear about, anything that you're still confused on. So, what did you guys learn and what is still unclear? So, what did you guys learn and what is still unclear? I'm looking through my notes because all the classes blend together. I was meeting with the dean this morning on something else, and I was trying to remember when something had happened. And all the days are running together. So, I understand. Um, it's, you know, everything becomes just this blur of sameness. Um, So that's not a bad question, right? Was last week the res ipsa loquitur, right? And the answer is no, right? But I can understand why you might think that because that's going to be the activity that we're going to do in a minute. Remember that when we check in, we're talking about uh, what was what we did last week, and then when we do the activity, we're looking back 2 weeks. Okay, so so welcome to our latecomers. Right now, we are having a conversation about, we're checking in on last week's material. So the question is, what do you feel like you learned last week? And um, what is still unclear? So Mystique says, we did foreseeability. So what did you learn about that? Foreseeability is a big topic. Like we could do a whole class on foreseeability, a whole course on foreseeability. Okay, causation and the different types of causation. All right. So what did we learn about causation? Again, very big topic.
We learned a lot about the but-for causation, that entire concept. We learned about the intervening cause thing and all the exceptions to the concept of causation in courts and all that.
Great. Okay. Outstanding. Wonderful. Is there anything that is unclear about the causation stuff? What are you guys still confused on? All clear? Okay. Anybody want to disagree or push back? We're good? Okay. All right. So today's activity is, as I mentioned, we're looking at res ipsa loquitur. And specifically, give me 1 second. It is. I'm going to put this into the chat for you so that you have it. And the task that you were asked to prepare ahead of time is to write a fact pattern that, if true, would give rise to an inference of res ipsa loquitur. This fact pattern should not match any case that you have read, either in this course or elsewhere. The point of this exercise is to think about what sorts of events are impossible in the absence of negligence. Okay? So the activity that we're going to be doing is, if any of you are educators or have done have any experience in the education field, this is what's called a think, pair, share. And if I was handing you this prompt cold, I would give you a few minutes to sort of spend some time thinking about your answer to it. Because you have already done that piece of it, we're going to move on to the pair. And the way that the pair works is we're going to put you guys into breakout rooms. No more than 3 people, very likely only 2. And you're going to explain what you have come up with to each other. So you're going to explain it to your partner. And you're going to explain what the fact pattern is, why it meets the standard of res ipsa. Then we are going to reconvene, and you will explain your partner's fact pattern to the class. And there are 2 reasons that we do it this way. The first one is it's important for you as future lawyers to get some experience in taking someone else's story and telling it in a way that makes sense. Okay? Clients will come to you and they're not necessarily going to give you a story that makes a whole lot of sense, and you're going to have to sort of rebuild it in a way that makes sense. Hopefully your classmates will give you something to work with that's reasonable, and you won't have to do that much reconstruction. But, starting with something that is easy to rephrase is the first step to being able to deal with a client who tells you something really incoherent that you have to sort of piece together. Okay, so that's the first purpose of this activity. The second purpose is to lower the stakes for you guys. Okay, sometimes people get nervous about presenting their own ideas, particularly in an environment like this one where we're going to sort of talk about it and hold it up to a standard and sort of see how it does in meeting that standard. And that can be sort of nerve-wracking for folks. But if you're presenting someone else's ideas, then, if there's something that's missing or something that doesn't quite meet the standard, well, that's fine because it's not your idea. And for the person who wrote the idea, you don't have to stand and deliver for this. You can do, sort of what I always do when I'm in these kinds of situations, which is, look down and avoid making eye contact with anyone at all costs, right? So, so this is the activity. Do you have any questions about what you're being asked to do? We're good? I'm sorry, Mystique, I didn't quite hear you.
Said I'm good.
Okay. All right. So I will warn you, Mystique, you may want to turn up your microphone or get it closer to your mouth, because I could make out what you were saying, but it was very difficult. So all right. So let me set up the breakout rooms for you guys. And there we go. And now they are open. So please go into them. Okay, welcome back. We are back on the record. So you guys know that I am always willing to call on people if I have to, but I prefer to give you guys an opportunity to volunteer. So is there anyone who would like to volunteer to go first to present their partner's fact pattern? I know going first can be scary, so. Any volunteers?
All right, good day, sir. I guess so will go.
Okay, thanks. Go ahead.
Um,
So whose fact pattern are you presenting? Give us the fact pattern and then explain why res ipsa applies.
okay. I am presenting Gian Mark Anson.
Okay.
And his fact pattern is that John, the owner of a vehicle, parked his car on a hill, which then, for some reason, began to roll down that hill, striking Mike, who was cycling at the foot of the hill.
Mhm.
The doctrine of res ipsa loquitur would apply in this instance, due to the fact that there had to be some form of negligence was John's vehicle to roll down the hill and subsequently it strike Mike. As John is the owner of that vehicle, he owed some sort of duty of care to not let it harm anyone in the general vicinity.
Great. So I think this is exactly right. Right? You've nailed the control element, right? John has control of the car, so he's responsible for it. And you've nailed the unknown negligence, right? Because maybe it's a maintenance issue. Maybe John forgot to put the parking brake on. Maybe, any number of explanations for what could have caused the accident, but all of them have in common that John was negligent in that case. So even though we don't know the specific explanation, we know that whatever explanation there is involves negligence.
Right.
So I think this is exactly right. I think this is sort of a textbook example of res ipsa. All right, so who would like to go next?
I could go next.
Great, go ahead.
So I am doing Amore's fact pattern.
Mhm.
And hers was that Jan Jan was a homeowner and she had a block on top of her house. And Rianne was walking by and the block blew off the roof and dropped on Rianne's foot. And I think that res ipsa locator would apply here because, like, why would you leave the block on top of the house? Like, the wind could be blowing, anything could have
Yeah.
happened. So I think that's very negligent.
Okay. So this seems like it's also sort of hitting the right spots, right? One thing to keep in mind that I think is raised by this fact pattern is that res ipsa creates a presumption. Okay, so if the plaintiff shows that res ipsa applies, then the defendant is presumed to have been negligent, but that is a rebuttable presumption. The defendant can come back and say, well, no, actually, I did everything that I reasonably could have done to prevent this accident. And so I am not liable. I was not negligent. And in this case, I think that may be where this ends up, because what I come back to is, if a block is heavy enough that it can injure someone by falling off a roof, unless it's a very tall roof, then it seems to me that there's a strong possibility that it's heavy enough that most reasonable, like, wind gusts wouldn't move it. So maybe the defendant's rebuttal is, look, a reasonably foreseeable person would not expect this block to move because it's heavy enough to sort of hold itself by its own weight. Is that argument going to fly? Maybe. I think that these become sort of very fact-driven issues and places where advocacy can play an important role in how the judges decide. But that would be sort of what I would expect. So great job, Jaleesa, presenting it, Amor coming up with it, and also, right, for our earlier presentation, Azizi, thank you for going first. I know that's always hard and scary. And thank you, John Mark, for your work in writing the fact pattern. Okay, who's next?
I'll go next.
John Mark, you jumped in first, so go ahead.
Okay, I'm presenting Azizi's pattern. It was where Regina was a pedestrian walking down the road, and she was suddenly struck by a refrigerator that fell off the back of a truck, and Alexis was the driver of that truck. Now, I think res ipsa could be applied in this situation because the driver, Alexis, owed a duty of care to motorists and pedestrians in the immediate vicinity of the vehicle, and she was responsible for whatever load she was carrying at that point in time. Also, a refrigerator is a heavy object, and it would not fall off of the back of a truck unless the truck was either being driven recklessly or the refrigerator was not properly secured to the back of the truck.
Right. I think that's absolutely right. Refrigerators don't tie bandanas around their head and jump out of trucks shouting Geronimo. At least I hope they don't. So I think that's absolutely right. You have the control issue. I think it's very likely that Alexis isn't the defendant who actually gets sued. It's probably their employer. But certainly that's, certainly if they're working for themselves, that may be the proper defendant, but the employer, their employer is likely to have the deep pockets, right? And you never want to, as a plaintiff's lawyer, you never want to be in a position where the only thing you get is a declaration of insolvency, right? So, but you're right about control. You're right about the lack of a non-negligent explanation, right? Other possible causes for the accident could include, right, a failure of the system for securing the refrigerator in the truck, right? So if it's tied down with straps, maybe a strap broke, or whatever system is used. And I think, all of these are negligent explanations, and there's room for the defendant to come back and say, well, no, actually, we did everything we were supposed to do, and the truck hit a massive pothole, and that knocked the refrigerator loose, and then it fell out, right? So maybe that's the explanation, and in that case, maybe they're not liable. But certainly, they should be asked to come forward with that explanation, right? The burden should be put on them. So great job. Thank you, John Mark, for presenting it. Thank you, Azizi, for coming up with it. So who's next?
I can go next.
Okay, go ahead.
I'm presenting Jaleesa Shepherds. The defendant was the cleaning company John hired to clean her office. The owner took the job and he uses a cleaning agent that generally takes 30 minutes to dry. So John leaves the office. However, after he has used the cleaning agent, he forgot to warn. The company usually warns the customers about the half-hour wait after the cleaning agent's put down. So after he's put the cleaning agent down, he has to leave for another job promptly and didn't warn Jan about the cleaning agent. So due to that, Jan went in the office and she slipped and broke her arm and fractured her ankle. So the rest is what liquidator would be that he breached duty of care to Jan and her workers. He didn't warn them and he left early.
Yeah, okay. So this strikes me as being a very clear example of negligence, right? I think that's very, very clear, and so that's well done. What I'm concerned about is that it seems to me that we can identify the negligent act. And res ipsa specifically applies where the negligent act cannot be identified. Because in the normal course of proving a tort, okay, the plaintiff has to show the actual negligent act that the defendant committed in order to be able to show that this act caused their injury, right? So if you can't identify the negligent act, you lose. Res ipsa is a way of getting around that by saying, look, I can't tell you exactly what it was that they did that was negligent, but we know they did something, because if they hadn't done something negligent, this wouldn't have happened. Okay? So that is the specifics of res ipsa. And I think that in this situation, because we know that what the contractor did was he failed to warn Jan that the cleaning agent was on the floor and that it needed to be allowed to dry before the floor was walked on. That was the negligent act. We know what it is. We know that it happened. And so I'm not sure that res ipsa applies, but I really appreciate the effort of trying to get there, and also a more of your presentation that I think laid it out very, very nicely for us. So who's next?
Yes, sir.
Go. Okay.
Go ahead, Mystique.
This is the second time Winston get cut off. But
Well, then I tell you what. Since that you are correct about that, and I missed that it was Winston. So Winston, why don't you go, and then we'll call on Mystique next. So we've got time for both of you. No, I want to hear what you have to say. Winston, go ahead.
Okay. Rihanna Mena, she
Okay.
gave me 2 instances. one where a fisherman caught a shark and kept it at the side of the pier for about 20 minutes. And he concluded that it was dead by then. And so he let some tourists ponder with the shark. And to his surprise, it wasn't completely dead and they got injured.
Okay.
So, we'll
So
say
why
that's
why would res ipsa apply?
because he was virtually certain that the shark was there and he couldn't expect that outcome.
Well, okay, so can we think of a non-negligent explanation for this, right? If it's normal for sharks to have died after they spend 20 minutes, I think was what you said, by
Yeah.
the pier. If that's normal, then probably it would be reasonable to expect that again. So how can we twist this so that res ipsa would apply? So the key piece, right, is that we can't identify the negligence.
It has to be
But so there's two key pieces here, right? We can't identify the negligence, and there's no reasonable non-negligent explanation. Okay, so in this situation, right, it seems to me that boy, I'm the only thing that I can think of might be yeah, this one's stumping me. I gotta be honest. I'm not sure how we can play with this to make res ipsa work. And some of that may just be that I don't know enough about fishing to sort of know what is and isn't normal. But so let me sort of throw this in a different direction and see if maybe this explains the concepts a little bit. If instead of the shark by the pier and the tourist who gets injured by the shark thrashing, instead of that, if we have a situation where a fisherman is standing on the pier or on the beach and is casting into the water, and they catch a passerby with their hook and injure the passerby by casting the hook through them. Okay. There may have been a mechanical failure, right? They may not have intended to cast the hook in that direction, or they may have not kept a proper lookout, or they may have.
Why this instance wouldn't be under res ipsa?
I'm sorry, say that again, Winston.
Exactly why this instance wouldn't be applicable, because like once the shark dead, then he shouldn't expect that to happen.
Yeah.
He wouldn't feel negligent.
Yeah, I don't know that I'm not sure that there's negligence in the fact pattern that you presented, because he probably would have reasonably expected the shark to be dead. So does the difference between the two fact patterns maybe help explain that? Do you feel like you maybe see the difference between your fact pattern and the one that I'm offering?
Kind of blurry.
I'm sorry?
Kind of blurry, the line between them.
Yeah. So let's see if I can make it clearer. So the key piece in the fact pattern that I offered you, right, of the guy who catches the passerby, the key piece of that is that, like, people don't go trying to catch, other people with their fishing rods, right? That's not really how we use fishing rods. At least I hope not. And so the fact that that's what happened suggests that the fisherman was negligent in some way. Again, right, it could have been that he didn't maintain the rod properly, and so it went off in a direction he wasn't expecting. It could be that he didn't keep a proper lookout and he cast in the direction of someone that he shouldn't have, or it could be that he, bumps the button that casts, that releases the line, and didn't notice, and so it went in the wrong direction. So, and we can't tell which of those things happened, but we know that something happened that was negligent, because if you're keeping a proper lookout, you don't catch people with your fishing line. So does it make more sense now, Winston? Okay, great. Thanks. All right. Mystique, you had volunteered to go next, so go ahead.
Right, so my person was Michaela.
Okay.
Okay, so it was this old lady. Well, a woman was responsible for taking care of an old woman. We didn't specify names or anything like that, so just an old woman.
Mm-hmm.
And she usually sets up the water for her to go and bathe, the old woman to go and bathe. But at this given point in time, she was on the phone and she believed or assumed that she turned the cold water on, but apparently that wasn't the case, and the old lady walked into the shower and she ended up getting burned. So I'm thinking that it could possibly be because she was on the phone, so she wasn't really paying much attention to what she was doing. So she probably turned the hot water instead of the cold, or probably had some kind of issue with the wiring for the shower or something like that.
Yeah. Okay, so I see how you are applying it. So here's what I think. Here's how I think I would analyze this. I think that you've absolutely identified a negligent act, right? The failure to turn on the cold water. And like I said earlier, if we can identify the negligent act, then res ipsa doesn't apply, right? Because it only applies in those circumstances where we can't prove the negligent act. I think that an issue with the wiring that you raise could be a potential defense to liability. And so that would be a situation where the aid could show, look, I did what I was supposed to do. I turned on the cold water, but because of a failure with the electrical system, the water was too hot, and so it didn't produce a comfortable temperature. So does that make sense? Kind of where we're coming from?
Yes, sir. So what I understand is that the one with the electrical makes more sense to use rather than she was on the phone and not paying attention.
Yeah, and the other piece of it is, right, that is the aid responsible for the upkeep of the electrical system? Because if they're not, then they can't have any negligence related to the upkeep of the electric, right? That's you can't be held responsible for something you're not responsible for. I don't know if that's pretty circular, but I hope it makes sense. So, okay. Last chance if someone wants to present, or if you have any questions, go now. Now is your time.
Okay, well, for this one, basically the lady was pregnant She went to the hospital, about to give birth and all that, and she had her baby. But when she came out of the hospital, she had a huge cut on her arm, not anywhere near a child comes out of. And we're saying that in that case, the doctor would be negligent, as in he did something wrong, obviously, if she had a cut on her arm. And you bring out the doctrine of res ipsa because the normal operation of giving birth doesn't result in a cut on your arm.
I mean, I get what you're saying, but I think that we keep coming back to, like, we know what the negligent act was, right? Somebody cut you. You know, like, we don't. I think that I think the issue you run into with this fact pattern isn't that we don't know the negligent act; it's that we don't know the negligent actor, right? And so we may be in a situation where the doctor or the hospital or the anesthesiologist are all different defendants, and there's not an umbrella of, like, who's responsible. And so we're not sure who's actually responsible. Now, the way that you deal with that as a plaintiff's lawyer is you sue them all and you let them fight amongst themselves. But I think that the issue that I run into with that is we know what was done to the plaintiff. What we don't know is who did it. Okay, so does that make sense?
How about if we would say that, like, if you had a midwife, you did a home birth and you had a midwife and you end up with a cut on your arm, then would it apply? Because it would be her. She's the only one here.
But it's still a situation where we know what was done to you, right? Somebody took a knife to you. Like, we don't have to draw upon the inference of res ipsa to prove negligence, because we know that somebody cut you. And that's not how that's that's a negligent act in this context, because cutting in that particular location would not have been required. Okay, and hopefully wouldn't be required at all, but I'm not qualified to opine on obstetrics. So Markela, you've had your hand raised. You've been very patient. You can have the last question or comment. Go ahead.
Hi, sir. I wanted to give Mystique's example.
Okay.
So hers was a babysitter. She was taking care of two children. One was out and another was with her. So she was on her way to collect the girl. She was late, but before she collected the child, she had to go and collect something from her friend. So she told her friend to come outside and wait till she arrived so she wouldn't get there too late for the child. So when she arrived, the friend wasn't at the door, so she had to rush. So basically, she thought she put the car in park and she didn't. And so the car rolled by and hit a pedestrian who was walking on the road.
So I think this is a really helpful example, because this is one where, as the story is told, we are told exactly what the negligent act was, right? It's that the babysitter forgot to put the car in park and the car rolled back. But if we look at it through the plaintiff's lens, right, the information that's available to the pedestrian, it may actually be a res ipsa case, because the plaintiff doesn't know why the car rolls backwards, right? This is much like the example that I think maybe John Mark offered earlier of the car rolling away into traffic, right? That's not normal, but there might be multiple reasons for it, right? And so we don't know what the specific negligent act was as the plaintiff, although sort of looking at it, as the omniscient writers, we do know, right? But the plaintiff doesn't know, and so the plaintiff might be able to invoke res ipsa in that circumstance. So really great. I appreciate that presentation, and I appreciate you coming in here at the end to make sure that we got it. So thank you. Thank you to all of you. I really appreciate the work that you did on this assignment. And with that, I will let you go because we're out of time. So I will see you guys next week. So take care and bye.